Let's turn now to Carol and Danny. So, Carol, first to you. I'd love your take on the prosecutor's opening statements, and then tell us what you think David Pecker's role as the prosecution's first witness tells you about the prosecution's strategy.
Right. So these are very typical opening statements, and the prosecution's job is to lay out the scenario so that the jurors understand each piece of evidence as it comes in and why that evidence is being introduced. And they didn't take a long time to do this. They told the judge they only needed 45 minutes. That's what they took. The defense took even less time, 25 minutes, incredibly short opening statements in my experience. And the defense's job, although they're not allowed to so-called argue in opening statements, they're just supposed to stick to what they expect the evidence to be, they started arguing. They started arguing points of law and such, and that drew some objections from the prosecution, and the judge sustained a couple of those objections. But really what the defense is trying to do is they're trying to say, and this is very typical for white-collar cases, well, this piece was not illegal, and this piece was not illegal, and this piece was not illegal, so how could anything have been illegal? And of course, the prosecution's theory is individual pieces may not be illegal, but where the intent was to commit some kind of crime or some kind of fraud, you put them all together and you have illegality.
So, Danny, what was your take on the defense's opening statement? Did they make a compelling argument?
Pretty standard. One thing that surprised me was opening with "my client is innocent." It really is an ambitious thing to say, because in a defense opening, you have to remember, you don't have any burden to prove anything. So you don't necessarily want to promise things that you're not going to prove. But there's a very big statement in announcing that the client is innocent, because all they really have to do is be not guilty. Innocence is not something a jury finds in a case like this. They find guilty or they find not guilty. But what Blanche is essentially saying is that this is not a thing where he squeaks by because there's some reasonable doubt. We believe he's innocent. And, of course, he plans to back that up, because you never make a promise in openings that you can't back up with evidence. And that's even more curious because the defense doesn't have to introduce one speck of evidence. They can rest after the prosecution's case on just that and say they haven't made out their case. But as expected, the defense pointed to certain witnesses and said they're not going to be credible. And again, I mean, echoing what Carol said, there really were no true surprises today.
So we do have a pretty important hearing tomorrow where the judge is going to hear arguments as it relates to the gag order. The prosecution believes the former president has been violating it. This seems to have been hanging over this trial from the very beginning. Carol, what do you expect to hear tomorrow during that?
Well, from the prosecution, I actually expect to hear that not only has he violated the gag order that the judge imposed several days ago by commenting about Michael Cohen and about Stormy Daniels, but he's been doing some pretty outrageous things right outside the courtroom, right after opening statements, coming out and really just, at this point, they may not be technical violations of the gag order, but he's really inviting the judge to impose even a broader gag order. And this is a very difficult decision because First Amendment issues and the current frontrunner for the Republican nomination and such. But I think that there is no other defendant in this country that could get away with making the kinds of statements that Donald Trump is making right outside the courtroom.
Carol, do you think he needs to be penalized at some point in order to rein it in? I mean, I know the judge has quite a bit of discretion as to what he can do to try and prevent the former president from continuing to at least walk right up to the line of violating the gag order. Does that need to happen at some point?
It does need to happen. I think that there are some constraints here. There's the bail reform law in New York State does limit what the judge can do. He can impose some financial restrictions, and maybe he needs to do that just to sort of send a message that if the defendant is going to ramp things up, the judge is going to have to take some more action. But the judge really doesn't want this to take over the trial. You can see it in the way he's handling it, putting off the hearing for several days. He doesn't want this to become a huge distraction for this trial. He's got a lot to do with this trial. The jury has a lot on its plate. And so I think the judge is doing what he can to compromise and try to just keep this trial on track.
So, Danny, we've obviously seen the former president not doing a very good job of controlling himself outside of the courtroom. he's not known for self-control. Do you think he would actually sit on the stand and testify in this case?
Yes, and part of me saying that just to be in the minority, because I think it's a safe bet, and the majority would think that he's not going to take this stand. Look, as criminal defense attorneys, we're naturally risk-averse. There's just too much risk in putting your client on the stand unless he has a piece of information that you absolutely cannot get from anywhere else. But that being said, look, we also know juries want to hear from the defendant, but Trump presents some very unique situations here. Number one, he doesn't believe that he can get a fair trial, so in his mind, he may be thinking, what the heck, there's nothing ventured, nothing gained, I'll take the stand. And point two, and I think a lot of criminal defense attorneys with white-collar defendants, there's this common theme, and I don't know why this is, but so many white-collar criminal defendants believe that if they just could take the stand and explain themselves, they're the smartest ones in the room and they could explain everything away if they just had the chance. So Donald Trump has an absolute constitutional right to testify. His attorneys have an absolute right to tell him not to do it, and he's got a right to ignore them and take the stand. Does Donald Trump think he's the smartest guy in the courtroom? Yes. Will he take the stand as a result? Yeah, maybe.
All right, Danny Cevallos, bucking the conventional wisdom. Let's clip this and hold it for later and give you all the credit when it happened. You're not so sure about that. All right. Carol and Danny, thank you so much for being here. We appreciate it.
Thanks for watching. Stay updated about breaking news and top stories on the NBC News app or follow us on social media.